Welcome to another session of CL4 company law. During our previous lectures and discussions, we dealt with several areas of the company law, in particular with the Companies Act of number 7 of 2007 in Sri Lanka. Today we are going to continue our lecture series in this area, and from where we stopped last time, I am going to start today, and we were discussing about the powers of management. I mentioned to you all that the management is mainly consisting of the directors who are engaged in the company affairs, since they are the main personnel officials rather who are engaged in taking the important decisions of the company. Apart from that, to help the company affairs, we do have other categories of officials in a company, such as secretaries, auditors, and so forth. So before I go into other categories, the main category that I mentioned, the directors, company directors, is what we are going to discuss now. As per section 201 of the Companies Act, a company shall have at least one director, except a public company which should have at least two directors. Now I need to clarify here that the present law on companies in Sri Lanka allows a company to run with a single director in the board. Now that is particularly for companies other than public companies. In the previous law, there was this requirement that at least there need to be two directors. But however, presently, even a one director company can legally exist. In the case of a public company, we know that a public company can be created or incorporated by a single shareholder, who is generally the secretary to the treasury, and a private company must have at least two shareholders. When it comes to the director board, a company other than a public company can have one director, but a public company must have two directors as per the section 201 that I showed you. Again, as per the section 202, it describes about the qualification to be a director. Now generally, people think that in order to be a company director, you need to have some qualification. Actually speaking, the particular educational or professional qualification is irrelevant. However, what is important to be a company director is that that person has the particular capacity to perform the due duties of a company. So, there is no particular educational or professional qualification to be a company director. However, that person has to have the capacity to run prudently the company affairs. So, if we look at the qualifications per se, section 2 describe that, section 202, I beg your pardon, describe that the first most important qualification is that a director to be appointed to a company needs to have attained the age of 18 years. This is basically the basic law in this country, that anyone who is under the age of 18 is considered a child or a young person. The Age of Majority Act in Sri Lanka makes proviso that a person attain the age of majority at the age of 18. Even though the Sri Lankan law is such that the age of majority is 18, different other countries may have different laws with regard to majority. Some countries consider the age of majority as 16, for example, or 17. But in our country, the age is 18 years. So, no one who has not attained the age of 18 years cannot be appointed a company director in Sri Lanka. And also the second qualification is that a person who is not declared as an insolvent also cannot be a company director. Now, what do you mean by being insolvent? Insolvent in the sense that the person is bankrupt. That means the law must recognize that a person is not capable legally to undertake affairs in a solvent manner, who has been declared by a court of law to be an insolvent or a bankrupt person. So, those who fall within that category cannot be made a company director. Thirdly, any person who was not prohibited to act as director under the former law, which is Act number 17 of 1982, cannot function as a director. Now, under the former law, the Companies Act of number 17 of 1982, there are several instances where either a person cannot be made a director, or he is prohibited from holding a directorship. And also, if a person who has been holding a post of director later on commit any act which is contrary to that law and made him prohibited from further holding the post of a director, then such person is prohibited from holding a directorship as of the present law. Then anyone who was not prohibited to act as director or promoter by virtue of operations of section 213 and 214 of the former law. Where a person who had been acting as a director under the former law that I mentioned to you has later on committed a wrongful act and thereby has been removed that person from holding the office of a director by a court of law, then such person also will not be able to be appointed a director anymore. Not only a director but also a promoter who has violated certain important elements that are required to be performed by a promoter, but thus violating such provisions, if he has acted, he or she, then in that case, that person is also prohibited from holding a directorship under the new law. So at present, no person can be appointed a director of a company if that person has been made prohibited from holding the position of a director or promoter as declared by the law and determined by a court of law. Such person cannot operate as a director anymore under the present law. Why in this section that they have referred the former law is that when the former law was repealed and the new law was brought in, the new law expected to give the particular flow from the former law to the present law, that whoever who was disqualified to be a director under the former law is therefore prohibited to be a director under the present law. Now this only applies to directors. Anyone who wants to anyone who has fallen into such a situation under the former law but want to invest in a new company as a shareholder, there is no prohibition as such, but he cannot become a director of the new venture. Then person who is not adjudged a person of unsound mind, a person who has been adjudged, that means pronounced by a court of law to be of unsound mind, a person having an insanity or who is insane, who does not have the proper sanity. In our general terms, we call such a person a crazy person. So, such a person having an insanity as adjudged by the court of law cannot be made a director. Now there are two circumstances here. One is that a person may be suffering from a curable insanity. The other situation is that a person may be suffering from non-curable insanity. Whatever the insanity is, if a person has been suffering from a temporary or permanent insanity at the time of an appointment as a director, and he has been so pronounced by a court of law to be a person of insanity, then he or she will not be able to execute functions as a director or to be appointed as a director. In the case of a temporary insanity, if a person has overcome his insanity at certain stage and he is cleared from a court of law that has earlier or previously determined that person as a person having an insanity, can be made a director if the competent court has pronounced that he does not anymore suffer from such insanity. Now you may wonder, how can a person be pronounced a person having an insanity? Either by the district court of the country or by the commercial high court in the country, whatever appropriate decision that has been given by such court, then he or she will not be able to be a director. If he or she has overcome a temporary insanity, then of course again that person has to apply to the appropriate court to be eligible again or freshly to be a director or to be appointed a director. Then the next one is that person who is a natural person and not a body corporate, which means that it's only natural people like us can become a director in a board, not an artificial person. Now I have explained to you that a company is an artificial person. Now just imagine a situation where company A and company B, say company B has taken certain shares of company A. By virtue of taking shares of company A, the company B doesn't become a director of company A, because the law does not provide the opportunity for a corporate body to become a director in a company. Then of course what this company B has to do, that the natural people like C and D to be appointed as directors for the shareholding that company B has in company A. So corporate bodies cannot become a director in a board. It is always the natural persons that are capable of becoming a director in a company. Then a person who is not qualified under the articles of the company. Now that is very internal for a company. Most of the other areas that we discuss up to now are external factors. But this is quite an internal factor, where the company constitution, the articles of association, has accepted the appointment of certain persons as directors of a company. Now take an example where a company says that in order to be directors of a particular company, where that particular company's articles of association say so, that a person of a certain background is ineligible to be a company director. Now, let us take a further practical example. If the company's article of association, if suppose that the company is a financial company, in that particular company's articles of association might say that directors to be appointed in this company need to be those who have accounting and legal knowledge. So, the directors can be either accountants or legal or both. So, an engineer, for example, may not be qualified to become a director of that company, because the articles of the association does not allow such a person to be appointed a director. So, this is very internal, where the articles of association provide so. Then further, with respect to that area that I mentioned, where the articles of association may not allow the appointment of a director, especially in the circumstances, the articles might say that a person who has not been convicted of an offence punishable by imprisonment under the present Companies Act until the lapse of 5 years will not be able to be appointed as a director. There are several sections in the company law that imposes penal sanction or imprisonment for various offences committed under the Act, Companies Act. In such a situation, when a court of law pronounce an imprisonment sanction against a director of a company, then the articles of association of a company might say that a person who has been convicted of such an offence under the Companies Act may not be qualified to be a director of this company until the lapse of 5 years after finishing that imprisonment period. Then another category of persons are a person who has not been convicted of an offence involving dishonest or fraudulent act. Person who has not been convicted of an offence involving dishonest or fraudulent act. A person who may not have done a fraudulent act or dishonest act, but still could be, if he has been convicted of a different offence, then even for that person until 5 years is lapsed from the time that person finishes his imprisonment. Here it says only been convicted, so will not be able to be a director of the company. So these are basically the qualifications and disqualifications. Other than that, there are no disqualifications as such. So, that is what I said, that a person, in order to be a director of a company, does not need to hold particular educational or professional qualifications, as far as he does not fall within those categories, or that the articles of association has specifically omitted or exempted such person being appointed, excepted from such person being appointed as a director. Now, the next area that we are going to discuss, the duties and responsibilities of a director, which is very important, because the day-to-day activities and operations of a company are conducted by the directors, as you know. When the directors take certain decisions, they are taking the decisions as the management of the company. When the directors are entering into contracts with outsiders, then they are acting as agents for the company, which is a artificial and juridical person. So, in performing the functions as a director, the directors do have certain responsibilities and duties as per the law. The first one is that a director should act in good faith. Now, this is a very important element, that every director in a company must act in good faith. Now, this good faith concept is twofold. Acting in good faith in a personal matter and acting in good faith for the interest of the company. Now, what should be here is the second one, that the director should act in good faith for the interest of the company. Why I am saying that is that there are sometimes arise situations where a director would be interested personally in certain company matters, especially when it comes to a certain private benefit that the director will obtain from a company. For example, say a director is interested in purchasing an asset of the company. In such a situation, what the director has to do is to leave away his personal benefit as far as the company is going to benefit out of such a purpose. If the director has involved in purchasing of such an asset, he should do so for the main interest and betterment of the company, not for him. I mean, basically he can purchase assets, but the purchasing of the asset must benefit the company. If it benefits the director over the benefits that the company is going to have, then you can't say that the particular director is acting in good faith. So, the company director should act in good faith and for the best interest of the company. This is what I mentioned. The check is that we need to see whether the company benefits out of that act of the director. If the company does not benefit, then that act of a director becomes bad faith. Good faith we say bona fide, bad faith we say mala fide. So, a company director must act in bona fide or good faith, and that should be for the best interest of the company. This is explained in section 187 of the Act. And also that a director is expected not to act in a manner contravenes with any provisions of the Companies Act. While performing his duties as a director, such director must not contravene or act in contravention with the company law, the Companies Act. Whatever that has been prohibited by the Companies Act, such director should not get involved. Thirdly, the company director should maintain the standards of care. Standard of care. The company director should maintain the standard of care. Now, standard of care in the sense that we know what is care. Care is how we maintain our acts. We may do good, we may do bad. The standard of care is the measurement that reasonable and fair acts are so performed. So, a director must maintain that standard of care by not acting recklessly or with gross negligence. A director must not act recklessly. You know what is reckless? Being reckless, right? And also not with gross negligence. Negligence in the sense that whoever who has the duty to care must act in such a manner that he care for that thing or to the circumstance. Then he should not breach his duty of care, and his act must not connect to the damage that has occurred, which we say the causation. So, a director shall not act recklessly and gross negligence, because that is the standard of care that they have to maintain, the director has to maintain as outlined here. And also apply skills and care expected out of a person of his knowledge and experience. Now, earlier I mentioned to you all that anybody can be appointed a director. It does not depend on the paper qualification or professional qualification or whatever. Anybody can be appointed a director, but generally a director is appointed to a company on the basis that that person, irrespective of his qualifications, whatever, has the natural skills and ability and care for what he does. So, directors are not appointed bluntly if a company is expected to grow. Shareholders may have money to invest, but if they feel that they are not good at a certain business, then those shareholders will appoint people who have such capacity and skills in doing such business. That's why they are appointed and put into such boards. Now take an example. Say a very rich man who has wealth intends to invest in a shipping business. Though he does not have the skills in the shipping business, he may have money and he may think that shipping business is a very lucrative area. So what he does is, he invests in ships, but he does not have the skills and ability to grow his business. So he is the shareholder, he selects some good shipping professionals or some reputed shipping personnel to act as directors of such a company. He appoints such people to his director board because of the fact that he expects the business to grow in this shipping company with the employment or with the appointment of such directors to the board who will take very good decisions in the growth of the business. When such directors are appointed, they are appointed because of their skills and the fact that they take a good care of the business. So ultimately, such directors are expected to carry out or to apply their skills and also the care expected by the shareholders out of a person of his knowledge and experience. Then the directors are also under the duty to use information and advice provided by an employee, professional advisor or expert, any other director or committee of directors. By being appointed as a director, no one should act in a stubborn manner, because whatever he does will positively or negatively affect the company affairs. So therefore, that person should, while acting with good care and good faith, must also use the appropriate information, either taking them from the employees who are working, or sometimes he may need to have a professional advisor who will advise the company in executing its businesses. You may have seen sometimes some companies require the services of a certain person who has a good knowledge about a certain area, and then use that service for the betterment of the company. Take an example. If a particular company wants to develop its IT sector, I mean IT within the company, having good softwares and so forth, the director may not be that competent in providing that service for the company. So the director or the board should in that case take good advice from IT professionals on how to set up a good sound IT system in the company. Then in that case, the director or the board should use such information provided by such advisors in utilizing the best possible solutions for the company to grow. The expert and any other director, sometimes within the inside the director board, there may be a director who is competent in a certain area, who will express his view on a certain thing, and the chairman may not be that competent. The chairman is expected to use the information of such a director who is providing his opinion at expert level or with his experience, or committee of directors who are appointed. Sometimes, as I mentioned to you at a previous occasion, there are certain committees that are appointed. Say a financial committee has been appointed, or finance committee has been appointed in a company. The chairman of the company is expected to listen to what the finance committee has said regarding a certain matter. So use that information for the betterment and the interest of the company. Then to disclose of any personal interest on the company transaction. Now this is what I have been telling earlier. A director may have a personal interest in certain things in a company, in a transaction. Likewise, where a director purchases certain asset of a company, if he is doing so, he is under the obligation to disclose that interest, personal interest that he has in such a company transaction. This can also happen when a certain procurement of goods are bought or done from another place that is owned by a director of this company. Now just imagine a situation where there is a company who wants to buy certain hardware items. A director of the company may be an owner of such a hardware store. The director might say that the company can buy the hardware stuff from his hardware shop. In such a situation, we know that the hardware shop would invoice this company, and the company comes into a transaction with that hardware shop. So the price invoiced, if it is more than what the hardware shop sell to others, and why the hardware shop has invoice at a higher amount is because this owner of the hardware shop is a director of the company, and because of such influence the company may come into that transaction. So who benefits and who loses? The director would benefit, the company would lose. So in such a situation, the law protects this artificial person by imposing a duty upon the director to disclose whatever the personal interest that such director may have in a transaction that a company enters, because this is a matter relating to undue influence and obtaining certain advantage by a director. Then a director is expected not to disclose information to which only the director has access in his capacity or being an employee. If certain secret and confidential information prevail with a certain director, and he is expected to keep this information to himself for the interest of the company, not to put it out or not to make it public, then in that case this director is under the obligation not to reveal this secret and confidential information that are important for the company's interest. So in such a situation, the director shall not disseminate such information outside. Now there may also be a situation where directors who have certain information must disclose that information to the company for the interest of the company. In that case, the director is obliged to disclose, not to keep to himself secretly, because that would be to the detriment of that company. Then disclose any share dealing having interest in share. Suppose that a director is involved in buying shares of the company and or becoming a shareholder, or if he is already a shareholder, then increase his shareholding by purchasing of shares. This quite often happen when minority shareholders who have a lesser amount of shares want to sell their shares at a higher price and walk out of the company. So when such interest is disclosed by such shareholders, then the directors of the company, whether they are existing shareholders or non-existing shareholders, such director may be interested in purchasing such shares. In such a situation, then whenever such director is intending to purchase shares, his intention must be made public. That director should always disclose any share dealing having interest in any share of the company. Then the director should prepare an annual report on the affairs of the company during the accounting period and sent to the shareholders. Now, this actually we discussed earlier with regard to company records. Every company is expected to prepare its annual report. Now, we know that the company cannot prepare its own annual records by itself, because company is an artificial person. It is either the directors have to do, or directors have to employ some experts to do that and then to table to the board. So, once they finalize the annual reports, they are obliged to send to the register of companies. If they fail so, now that is a violation of the company law, for which the directors would be guilty of committing an offence. In that case, the duty or the obligation to prepare the annual accounts rests with the directors or the board. So, the directors are obliged to prepare an annual report on the affairs of the company during the accounting period and send it to the shareholders, because shareholders are the real owners of the company. They need to be informed of what is happening in the company. They are the real decision makers. As you know, directors are the agents of a company. They have been put to those places by the shareholders. So, the shareholders should be informed, made aware of the day-to-day, or rather the periodical affairs, the affairs of the company. So, the directors are bound to prepare and disseminate the annual reports. Not only the shareholders, but also they are obliged under statutory law, the Act, to inform or place it at the ROC, the Register of Companies. Now, there are also sometimes situations where the directors become disqualified to act as director. Now, we discussed about the qualifications earlier. However, sometimes with the continuance of a company, an appointed director might be disqualified later on. How that can happen? How can that happen? Especially where the director is convicted of an offence punishable by imprisonment under the Companies Act. Now, as I previously mentioned to you, the directors are obliged to comply with the Companies Act, especially with regard to statutory obligations, where the directors have to report certain things and to act properly with due diligence in the company. Their failure to do so might lead to the fact that the company registrar take action against such company for not complying with the company law. The jurisdiction to complain of such mishandling or failure to handle the functions of a director would lie in a magistrate's court the lowest court, or it may lie within the jurisdiction of the district court, or even within the commercial high court. There are certain provisions in the Companies Act that require directors to act in certain ways. If they breach them, or if they fail to do so, might end up in penalizing them. While certain offences would amount to payment of a penalty, certain offences in that act amount to imprisonment. So, failure to do such act might also amount a director to be imprisoned. Now, suppose that a director of a company falls into such a situation and statutorily under the act he is so penalized by a court, competent court that I mentioned. The director who serves or who is convicted of an offence punishable by imprisonment will be straightaway disqualified from holding an office as a director. And second situation is where a director is convicted of an offence involving dishonest or fraudulent act. If the director has committed an act of dishonesty towards the company, or a fraudulent act against the company, then if he has been convicted for doing so by a competent court, then he is discontinued and disqualified of holding the office of a director. Or that the director is adjudged to be of unsound mind. As I told you earlier, generally those who are of unsound mind are not able to be appointed a director. But there can be this insanity coming later on, that while holding an office as a director, that person falls into an insanity. Then in that case, the moment that that person falls into that insanity, he is disqualified from holding the office of a director. Now, virtual insanity is not the ground here. It is a judgmental insanity, or an insanity as adjudged by a competent court. Suppose that a certain director is suffering from an insanity, either the board or the shareholders must then report it to the court and obtain a certificate of insanity from the court to disqualify such a director from holding the office of a director thereafter. Or that a director is prohibited by court of law to be a director. Now, suppose that while holding office as a director, that director has committed a wrongful act, either illegal act or mismanagement or oppression. An act that is oppressive, or the director has mismanaged the affairs of a company. Then in that case, if he is found to have committed such an act, the court will be eligible to disqualify such a director. Now, this has to come from the court itself, not automatic. He has to be adjudged by the court to be disqualified from the post of director. And also, where a director is persistently failed to comply with the provisions of the Companies Act. Now, this is in contrast to the earlier situation we mentioned about, who has failed to perform certain things has been convicted. So, this is a situation where the director is persistently failed to comply with the provisions of the Companies Act. Now, that also has to be adjudged by the court. If the court so adjudge on a complaint made by shareholder or director, then in such a case, from there onwards, such director cannot be or cannot remain in office as a director. So, he will be disqualified to be a director. A director who is convicted of an offence involving dishonest or fraudulent act abroad. Now, earlier situation where we discussed about a fraudulent act or act of dishonesty committed in Sri Lanka. But also, there is provision that if a director has committed an act of dishonesty or fraudulent act abroad, out of the waters of this country, outside the waters of this country, then in that case, the director will be disqualified. Now, what is important here is that the matter of dishonesty or fraudulent act need not be associated with the particular company that he is acting as a director. Now, just take an example. If a director of a company in Sri Lanka has committed a offence of money laundering outside this country, that is punishable and punished outside this country, then in that case, the director, who may not have committed anything wrong to this company in Sri Lanka, but has acted dishonestly or in fraudulent manner, then such director can be disqualified upon the judgment of a competent court, even abroad, pronounced in a foreign court even. Or that a director has been responsible as a director of a company that was declared insolvent. Where a director who has been there holding a directorship in a company and he has been adjudged to have been responsible for that company to collapse. That means that when a particular company runs into an insolvency or bankruptcy and the particular director has been held by a competent court to be responsible for that, then that also will make such director being disqualified. You may remember when we did on acts of ultra vires and veil of incorporation, I told that directors are protected from the veil of incorporation. But if the court lifts the veil of incorporation, find out that a particular director has been acting in ultra vires and that has caused detriment to the company, and the company has suffered, resulting in quite of a bankruptcy issue, then the director could be personally liable. So, this area stems further from that aspect where a director becoming responsible for the bankruptcy or becoming insolvent of a company, that director will not be able to continue further as a director and he will be disqualified. Now, you may wonder, when a company goes into bankruptcy, then such director, anyway the company will close and the director will not be able to stay. That is true. Then the director will further be prohibited from holding office even in a future situation, future company or in another company. But also that there will be a situation where a company that runs into insolvency or bankruptcy is protected by the court to resurrect that company. Then in that case, such as for example appointing of receivers and so forth, and then to continue the company to a certain extent, then in that case, however the director who is responsible for such act that led to the bankruptcy cannot remain in the new circumstance of revamping the company or resurrecting the company, or the time that the official receivers are doing their best to either close or to revamp the company. And finally, the retirement age of a company director is 70 years under the law. So, whoever who has attained the age of 70 cannot thereafter remain as a director of a company. Now, this is a situation that was brought newly in the present act, because in Sri Lanka there were many issues with regard to people of old age acting as directors. And in the financial sector, you may also have heard certain financial institutions in this country collapse due to the fact that the directors were of old age and their decisions were not that efficient, and that led to the collapse of such financial institutions. This is why the law has imposed a maximum age to be involved as to be appointed or remain as a director. And with regard to financial institutions, there is special provision for financial companies that their retirement age is much lesser than 70. But for companies, other companies, the company law will apply so that the retirement age is 70 years. That is the maximum age that a person can serve as a director of a company. As per section 206, a director can be removed by ordinary resolution passed at a meeting in line with the articles of association. Now, what we are coming now is situations where one can remove a director. It's nothing to do with disqualification, but in what circumstance a director can be removed. A director of a company can be removed by an ordinary resolution. passed at a meeting in line with the Articles of Association. If the Articles of Association so provide for the removal of a director, the removal can be done by an ordinary resolution. Now, ordinary resolution to be taken by whom? By the real owners of the company, who are the shareholders of the company. So, whether it is going to be a major shareholders or minor shareholders, or together major and minor, whatever the meeting that they are going to call based on the minimum requirement of shareholding, such meeting convened must be called for the purpose or for purposes that include the removal of the director. So, the agenda of the meeting must mention that this particular meeting is brought for the removal of a certain director or directors, and it is intended at this meeting that an ordinary resolution is to be passed by the shareholders to remove such director or directors. Such notice called in the meeting shall state that the purpose or a purpose of the meeting is the removal of the director. So, the notice can carry the convening of the meeting, but it must say that one of the business or the main business of such meeting is to remove a certain director or directors from holding the directorship in the company. When the director concerned makes representation within a period of 14 days of such notice with a request to send copies to all shareholders, the company shall send copies of the said representations to all shareholders. Now, when a meeting has been notified for such a purpose of removing a director, the director who is now under the accusation and to be removed will obtain a fair opportunity of explaining his case. That he has to do by notifying the shareholders of his innocence or justification against the complaint matters, and such notice should be sent to the company within 14 days from the date that notice of a meeting to remove that director is dispatched. When the company receives such a explanation from the director who is in trouble now, the company must send that communication to all the shareholders, and that justification, clarification of this particular director situation sent by this particular director needs to be read at the commencement of the meeting, so that to make sure that a fair chance of a hearing is provided for that director who is to be removed. Now we will come to the next category, next important category of officials in a company. They are the secretaries of a company. They are the secretaries of a company. According to section 221, every company shall have a secretary. Now, that is very important. No company in this country can run without a company secretary. Now, one must wonder whether such secretary should work in the company. Now, when you talk about secretaries in a company, there are two types of secretaries. The secretaries that are working as secretaries for various officials or employees or whoever in a company in different sections maybe. Here what we are talking about is not that category. Here what we are going to talk is about the company secretary, the secretary who has been appointed as the secretary for the company. That particular secretary is named the company secretary of the company, company secretary. Every company, as per the law that I explained, requires a company secretary to be appointed, and such appointment should be informed to the ROC, Register of Companies, with the particular data provided in the relevant form required by the required statutorily by the Register of Companies. Once a company appoints a secretary, the ROC will always deal with that secretary. Whatever the information that is required, this particular company secretary will be obliged to provide. And it is the duty of the secretary to provide all the company records and so forth to the ROC, Register of Companies. A company secretary is virtually the link between the company and the Register of Companies, and statutorily it is very important to have this link, because as the caretaker or the regulator of a company in Sri Lanka, the ROC or the Register of Companies require that this link is maintained so that all the necessary informations are informed or made to the company Register of Companies. One may wonder whether there has to be certain qualifications to become a company secretary. Yes, it is. Unlike the case of a director, a company secretary must be a qualified company secretary. Who can be a company secretary? Generally, attorneys at law, lawyers, can become company secretaries. Accountants who are professionally qualified can become company secretaries. However, the qualification itself doesn't provide the title. Those who are qualified must obtain a certificate from the Register of Companies to function as a company secretary. So, once you obtain your chartered qualifications and become a professionally qualified chartered accountant, then you can apply to the company registrar for a certificate to be appointed as a company secretary. Then, after receiving such certificate, you are a competent company secretary to handle the secretarial work of a company secretary. This company secretary can either be a natural person or a firm or a partnership. If the company secretary is a person, that company secretary must act by his or her name. Such as, for example, the company secretary is Mr. Mark Anthony or Mrs. Sandhya Fernando, whoever. There can also be, this is one situation, personal. There can be another situation where there can be a secretarial firm that is either of a proprietorship nature or as a partnership. So, if it is a kind of a proprietorship business, say there can be a business style such as A and S secretary or secretaries, whatever. This is a partnership. Partnership between some A and S. There can be a proprietorship, for example, Canwell Secretaries, which is a sole proprietorship perhaps, conducted by one person as a sole proprietor. Partnership or a sole proprietorship, and this is a firm. Third is that it can be another company, what we call a secretarial company. We can say, for example, Michael Silva Secretaries Private Limited. That means, like the Solomon and Company, we saw it can have a name like Michael Silva, but with the style that it's a company. So, either of the ways, such a company, secretarial firm as a partnership, sole proprietorship, or a company can remain, or as an individual person. So, this is person, first category, this is a firm. But however, what is important is that these particular situations where the personal or firm is registered with the company ROC, Register of Companies, and obtain a certificate to function as a company secretary. Otherwise, such a unregistered person or company firm, or firm, cannot exist as a company secretary. So, this is very important. No person shall be appointed as a secretary of a company unless such person has, in the prescribed form, consented to be a secretary of such company. Which means that a company secretary who is appointed as a secretary of a particular company has to fill the relevant form and submit that to the ROC, that he or she or the firm will be the company secretary for this particular company. Then the ROC or the registrar is informed that whatever the particulars that the registrar requires, then to obtain from such registered secretary for this company. So it should be by way of the standard form provided in the company ROC, Register of Companies, that the particulars of the secretaries, like we are doing with regard to the particulars of the directors, such forms should be submitted. And these forms should be certified that such person has such qualifications as may be prescribed. That is, generally that person or the firm has the certificate to practice as a company secretary issued by the Register of Companies. Not the professional qualification or the academic qualification, but the certificate issued by the ROC that a particular person or the firm can function as a company secretary. In relation to that company, having regard to the nature of the duties, and secretary will be called upon to discharge. Because the secretary is expected to discharge the functions as per the Companies Act. This is very important. It's a statutory obligation that the secretaries will have to fulfill in the continuance of a certain company. So secretaries must inform everything that is required by the registrar, including the details of the registered office. If it changes, to be informed to the ROC, the particulars of the directors and shareholding required, and also at the beginning, at the time of the incorporation and inception, it's a secretary who has to generally submit all the company articles and registration forms and everything. And thereafter, in the continuance of the company or the existence of the company, the company secretary is expected to send all the reports that are required statutorily, such as the annual reports, then minutes of the board meetings if required at any time by the ROC, and other such details as the particulars of the company. The next category of officials are called the auditors of a company. Now, auditors are, of course, mainly designated or separated to accountants who have the knowledge of accountancy, and especially the law requires that he or she should be a chartered accountant or management accountant, whatever, to be an auditor. I don't have to basically explain to you what kind of a role that an auditor performs, because as students of the Chartered Accountants Institution, you know what sort of roles that the auditors perform in the financial aspects of a company. As per section 154, a company shall at each annual general meeting appoint an auditor at each annual general meeting, important agenda number should be the appointment of the auditor. Practically, when the new board is appointed, new chairman, whoever appointed, or they have been retained for the next year, the next business to be discussed in the AGM agenda is the appointment of an auditor for the next financial year. It could be the same person to continue or a new person to be appointed. Whatever, it should be an agenda item, and that should be expressly minuted as taken up in the board or in the AGM, the annual general meeting, and the appointment should be expressed. Whether you retain the same auditor or you are going to bring in a new auditor. He is to hold office from the conclusion of the AGM until the conclusion of the next AGM. And within that year, within the new year, this auditor is expected to audit the financial aspects. Now, when I say financial aspects, it is not only the liquid money, how they have been transacted, also the assets of the company, including the new assets that come in, the old assets that are being sold, or the continuing assets that needs to be inventorized and determined of the depreciations. So, all these things have to be done by the auditor. Audit the financial statements of the company for the accounting period next after the balance sheet date for which financial statements were audited. If an auditor is not appointed or a casual filling does not take place, the registrar may appoint an auditor with written notice being given of such vacancy exists within 5 days. Now, as I mentioned to you, if at the AGM an auditor has not been appointed, maybe due to a mistake or intentionally, whatever the reason, the registrar has the power, the registrar of companies, ROC, has the power to appoint by himself an auditor for this company. This is to ensure that no company in this country will go without proper audits. That is to make sure again and to safeguard that artificial person, the company. So, the law and the statute has brought in various means of mechanisms to protect this artificial person, company. So, if the company fails to appoint a registrar, to appoint an auditor, the registrar can appoint an auditor with written notice being given of such vacancy if existing in the company. Then within 5 days he has the power to appoint such person. A person shall not be appointed or act as auditor of a company unless that person is a member of the Institute of Chartered Accountants of Sri Lanka. This is what I told you before. Mandatory for the company other than private or guarantee. It is mandatory for companies that are not private or guarantee company, basically the public company, to have a person as an auditor being appointed where that person holds the qualifications as a chartered accountant awarded or is a member of the Institute of Chartered Accountants of Sri Lanka, who has how to get the membership. You become a member of the Chartered Accountants by passing your exams, all exams, and you will be entitled to become a full member of the Chartered Accountants. Or any person who is registered auditor. I told you that there can be other qualifications such as management accountants of another institution. Then in that case, such person, in addition to his professional or academic qualification, must obtain a further qualification of registering as a registered auditor under the laws of the state, country, and by obtaining the necessary clearance from the Auditor General. So, one has to become either a Chartered Accountant, member of the Chartered Accountants Institution. Here, you automatically become entitled to practice as an auditor, or whoever who does not have the Chartered Institute Accountancy qualification or membership, then to register him or herself as an auditor who can practice as an auditor. Only those two categories of persons can perform the duties of an auditor under the company law. None of the following persons may be appointed or act as an auditor of a company. But however, no one falling within the categories that we are going to discuss now should be made an auditor. Who are they? A director or employee of the company. A director of that particular company or an employee of that particular company shall not be appointed the auditor of that company. A person who is a partner or in the employment of a director or employee of the company. A person who is a partner or in the partner of a partnership or in the employment of a director or employee of the company should not be appointed an auditor of that company. A liquidator or an administrator or a person who is a receiver in respect of the property of the company. When a particular company runs into receivership, the receiver who is then attending to the receivership of that company, or a liquidator appointed for that company, or an administrator who is appointed for that company, cannot be appointed the auditor of that company, Then a body corporate. Now here we discuss about a body corporate, but in the case of an auditorship, auditor's firm that is incorporated cannot be made an auditor of a company. So the law does not provide the capacity, opportunity for a auditor's corporate firm to be appointed an auditor of a company. Now it is not only in the case of the auditor. You know, generally you may have heard of law firms in Sri Lanka. In our law, unlike any other law in another country, in our law, a lawyer's firm cannot be a body corporate. It can only be a partnership business. If, say, a law firm is to be created, that law firm should be either a sole proprietorship or a partnership. It cannot be a body corporate. Like, for example, A&S Lawyers Private Limited. No, you cannot. But A&S Lawyers, Associates or Lawyers, whatever, no problem, as long as it's a sole proprietorship or partnership. So likewise here, an auditor's firm that is corporate is not recognized as a proper audit firm. It can be a partnership as long as it is not a corporate. Then a person who, by virtue of paragraph A and B, C above, may not be appointed or act as auditor of a related company. Now one may find that, for example, a director of a company, we know that cannot be appointed an auditor of that company. But can he be appointed an auditor of a related company to this company? No, that's also not possible. Either of the holding company or a subsidiary company. He cannot be appointed. But a director of company A who has no relationship to company B, that director can act as auditor for company B. That's not a problem. But whereas the company A and company B fall within the same family, either subsidiaries of a holding company, or where one company is a holding company of the other, then in that case it is not possible to be appointed an auditor. A partnership firm is eligible, as I told you before, to be an auditor. Anyone falling under ABC above that we discussed, who has ceased to be such officer, is unable to be an auditor for the next 2 years. Now, a director of a company cannot be appointed an auditor of that company. But if he ceases to be a director, and if he is to be made an auditor of this company, then he has to wait for another 2 years to be eligible to be an auditor of this company. Until 2 years is lapsed from cessation of office, he or she cannot be appointed an auditor of this particular company. An auditor of a company shall, in carrying out the duties of an auditor under this act, ensure that his judgment is not impaired by reason of any relationship with or interest in the company or any of its subsidiaries. So what it says is that the auditor acting as an auditor in the company must execute the due diligence in doing the best for the company, and also should not have any conflict of interest and undue influence in the company, because his duties as an auditor are very important for the benefit of the company's financial position and financial dealings, that he prudently acts for the main benefit of the company or its subsidiaries and its subsidiaries. As per section 163, the auditor of a company shall make a report to the shareholders on financial statements audited by him, and generally this report is submitted at the AGM every time once a financial year is completed, either in December or in March. The auditor must give its report and present it to the annual general meeting. This would benefit the shareholders in understanding the position of the company. Now you may remember some years back there was a huge company legal battle in United States. And there the auditor's report was a gross violation of the standards of audit. This auditor's report gave a wrong picture to the investors, shareholders and prospective investors, and that resulted in a total collapse of a company called Enron, and it became a talking point in the entire world that when auditors give a wrong picture of a company, this would not only affect the company shareholders or prospective shareholders, it would also affect the entire national economy of that country. If it's such a important company in the country. So therefore, in providing the report, the auditor shall state the basis of his opinion, the scope and limitations of the audit. Once he conducts his report, he has to give an opinion of the financial statements, the basis of the report. And also he has to unveil the scope and limitations that he audited. Whether the auditor has obtained all information and explanations that was required, whether it is exhaustive. In the auditor's opinion, proper accounting records have been kept by the company. So, a statement of the affairs of the company and whether the company has kept proper financial statements of the company. Now that is to show that the company has been acting diligently or not. Then in the auditor's opinion, the financial statements give true and fair view of the matters to which they relate, and if they do not, the respects in which they fail to do so, so that the shareholders get a proper picture of the company affairs. In the auditor's opinion, the financial statements comply with the requirements of section 151 and section 153, that is, give a true and fair view of state of affairs of the company, income, expenditure, loss, profit. These are statutory requirements, as the case may be, and if they do not, the respects in which they fall to do so. Now, while the auditor's report provide a good and fair picture of the company, providing a bad report by the auditor may run into liability issues, where the auditor will be personally liable. If it's a firm, the firm will be liable for giving a bad report. This is what happened in that US case, where the auditor's firm was held to have breached the law. Then in that case, the auditor will be in danger. The auditor will be liable and liable to pay a fine, or sometimes may even go to the extent of imposing imprisonment period, because the auditor's report reflect the company's true picture. If the auditor does not provide the true picture, then the auditor becomes personally liable for doing so. Next is that we are going to do an exercise, and In task 1, Nimali, the secretary of XYZ Limited, was asked to call the annual general meeting AGM of the company for the year 2019. In every year, the balance sheet date of the company is 31st March. The AGM for the year 2018 was held on 31st May 2018. Accordingly, Nimali has scheduled to hold the AGM of the company on 30th July this year, the last year, 2019, the new one. At the AGM, a shareholder, Mr. Pereira, had questioned the legality of the duration of the AGM for the year 2019. What is required is to explain whether the company legally held its AGM for the year 2019. Now, generally, what we have to discuss here is that AGM is an annual thing, annual general meeting. So, the annual general meeting should be conducted every year as per the Articles of Association and the law. And also the annual accounts need to be submitted along with at the AGM. We have discussed previously on the matters pertaining to this under meetings and annual general meetings, where we have mentioned that you can see at the top, as per section 133, an annual general meeting of shareholders to be held once in each calendar year, not later than 6 months after the balance sheet date of the company. In the present task, the balance sheet date is 31st March. So, 6 months period within which is April, May, June, July, August, September. So, before the end of September, or rather the 30th of September of that year, the AGM should be called, and not later than 15 months after the previous annual general meeting. So, in the first way, we have date till September 30th of 2019. But however, in the task it says that the earlier AGM was held as per the question 31st of May 2018. So, which means from there onwards you have to conduct the next AGM within 15 months. So, 15 months means 12 months is 30th of April 2019. Then you have 3 more months, May, June, July. Before July 31st, the AGM should be called. So, here the new AGM is the 30th of July. So, which is really at the deadline, So, in this particular case, the AGM was called really at the deadline. So, what you need to explain all these matters as per the statutory requirements and to show the legality of holding its AGM for the year 2019. Even though the accounts allowed you to hold the AGM before 30th of September, due to the fact that the previous AGM was held 15 months before, that really gives the deadline date of 31st July, the holding 30th of July AGM is not an issue. In the task 2, Nilmini, the secretary of the company, further has the following questions. Now Nilmini, the secretary of the company, has the following questions. The duration of notice of annual general meeting to the shareholders. How company can validate an AGM which is called by a shorter notice to the shareholders. The duration of notice of extraordinary general meetings EGM to be shareholders of a public company. How company can validate an EGM, extraordinary general meeting, which is called by a shorter notice to the shareholders. You are required to advise secretary considering the provisions of the Company Act. So I have made out certain tips for the task 2. In the first one, where the question was that the duration of the notice of annual general meeting to the shareholders. What is the duration? A notice of the AGM should be given to every member of the company at least 15 days before the meeting to be held. Second, how company can validate an AGM which is called by a shorter notice to the shareholders. If a meeting is called as the AGM by shorter notice, and if all the shareholders who are entitled to attend and vote at such general meeting so agreed to call a meeting at a shorter notice, the AGM is deemed to have been duly called. AGM. The duration of notice of extraordinary general meeting to shareholders of a public company here. Generally, to call an EGM in a private company, 5 working days notice should be given by the directors. In a public company, 10 working day notice to be given. However, at the EGM, if any special resolution is going to be passed, then not less than 15 working days notice shall be given in both private and public companies. Fourth one, how company can validate an EGM which is called by shorter notice to the shareholders. If a meeting is called as EGM by a shorter notice, and if the shareholders together holding not less than 95% of voting rights who are entitled to attend and vote at such AGM, so agreed to call the meeting by a shorter notice, the EGM is deemed to have been duly called. If that is fulfilled, then the AGM is said to have been duly called. So I think with those 2 questions that I did, that were based, they also based on the areas that we discussed in the previous lecture and this lecture. I come to the conclusion of today's lecture, and we will have our next session on the next day that will be based on the Indo management rule and the solvency test of a company and the other matters that we will be discussing. So with that, I would like to thank you all for listening to my lecture, and I hope that you all have now progressively gain in knowledge on this area of CL4 company law. Thank you very much for listening.